Good morning and welcome to the MHC in-house Masterclass for IP on what is World IP Day 2023, and the theme being Women in IP, Accelerating Innovation and Creativity. We have three speakers this morning. Myself, Jerry Kelly, the head of IP at MHC. I'm joined by my partner, Hazel McDwyer. And indeed, we have a guest speaker, Dan Plain from SIPS, who's going to give us an insight into protection of IP in China and how to negotiate those pitfalls when dealing with that jurisdiction. So I'm going to start off by looking at some developments in the area of IP that has happened over the last year or so. And I'm going to deal with four of the main IP rights: trademarks, designs, copyright, and patents. So talking about trademarks first, just to look at some sort of new developments in that area, which we'll see perhaps as themes that will generate going forward. We've seen for the first time a face being now registered as a trademark. This is quite a significant development. A Dutch model has achieved that in the area of image rights, for example, where celebrities had to rely on things like passing off and showing an endorsement that was false. Here with a trademark, it's going to be much simpler. So perhaps we'll see this happening more going forward. We also have
Thank you, Super Simon.
A multimedia mark where Super Simon, that the sound isn't available on this, but effectively this has been registered as a trademark now on appeal at the EU IPO. The multimedia audiovisual collection of sounds and images is something which is accepted now as a trademark because it's recognized that packaging can be more elaborate. It can have digital media on it, and indeed QR codes could be scanned. So this was an application made by an IP firm in the Benelux to test the waters in that, and I'm sure we'll see more. We've also seen Amazon subject to a trademark infringement action and an attempt to make them liable for counterfeit Louboutin products that they sell on their marketplace. They sell obviously Amazon products, but they also sell third-party products and in fact ship and stock them. So here it was held that without a sufficient distinction between who's ultimately responsible for the goods, etc., the online marketplace can be held liable as an intermediary. So we might see how that develops in practice. We've also seen in the United States NFTs being pursued for trademark infringement. Here we have a Birkin handbag, which was claimed to be an artistic depiction, but sold by an individual. And this was held to amount to trademark infringement when Hermes took a case in that jurisdiction. We've also seen the famous sort of Banksy, the anonymous artist who I would have dealt with last year, the flower thrower case, where it was held that because it was a copyright work, it couldn't be protected as a trademark and therefore was sort of bad faith. Here is a different decision in respect of the Laugh Now work that he has created. Obviously, he'd have to identify himself, or she would have to identify herself if there was copyright infringement being pursued. So trademarks obviously alleviated that particular problem. And it's held that it's not bad faith if the artistic work can act as a badge of origin. Looking now at some interesting cases around shapes, because again, if you can get a trademark for the shape of a product, it is quite a good IP right to have. We've seen Absolute Vodka succeed in getting this protected as a shape on the basis that certain of the imagery that you see there, that the copper coloring in the background, the frame sticker and the sort of copper top are not considered customary in the particular sector concerned and therefore can be protected. An unsuccessful case was recently taken by Christian Dior, where their saddle handbag, which has been around for over 20 years, could not be protected as a shape mark because it was considered that handbags and purses come in a variety of shapes and wouldn't be perceived by consumers as an indicator of origin. Again, looking at whether shapes depart significantly from the norm in the particular sector concerned. However, if you have a common shaped product, such as this baby's bottle, you can have it for confectionery products, which successfully was registered here, because that isn't clearly what the shape is ultimately used for. It's used in a sort of a different context here. And again, we've seen McCain successfully defend a challenge taken against their smiley face potato frozen products. And here it was challenged on the basis that it's pretty commonplace to have smiley faces, but it was held that this was being used in a trademark sense. It was advertised as smiley face,
The packaging was transparent, so it was seen at the point of sale. And on that basis, it could be protected as a relevant shape mark. Just looking at some of the more interesting challenges to marks over the last year or so, we've seen that Iceland, the supermarket, which has a presence in Ireland, more so in the UK, has had its mark successfully challenged by the Icelandic state on the basis that it was considered to be geographically descriptive of that country. And the country wanted to ensure that businesses from that country were able to, use that, and it wasn't monopolized by a particular entity. So Iceland wasn't able to put forward sufficient evidence to show that it was solely associated with the name in that sense, and therefore the mark couldn't be registered. Shukra, the Irish for sugar, a very famous brand here, their mark was challenged and considered descriptive for sugar products or sugar-based products, but they were able to show sufficient use to gain a secondary meaning that the Shukra brand was considered a badge of origin in the minds of consumers, and that challenge was unsuccessful. We've seen here a My Bacon application, which wasn't for pork-based products, as you'd associate the word bacon more commonly with, but in fact, plant-based or fungi-based mycelium products. And it was considered to be deceptive by the office, was unsuccessful on the basis, as I said, that bacon products would be understood more with the meat-based product and not with sort of artificial substitutes, etc. And therefore, it couldn't be registered on that basis. And indeed, the long-running saga between Supermacs and McDonald's as another iteration. I've dealt with this in previous talks. McDonald's had their Big Mac trademark challenged on the basis of non-use, and perhaps in what was an aura of complacency, was only able to prove evidence for the actual hamburger itself under the brand. Now, on appeal, they put in additional evidence and managed to show use in the context of restaurant services, for instance, and a broader range of food-based products. It wasn't accepted that, in fact, they had used Big Mac, let's say, in respect of the constituent ingredients, such as the lettuce, the pickle, the sauce, but indeed they were allowed put in additional supplementary evidence to show that their mark was being sufficiently used. We've also seen a decision around whether you can defend a revocation action or indeed multiple revocation actions. Here was a dispute between Formula One, obviously the organizers of the famous car races, and a German individual who had set up sort of a shop dealing with medals and trophies, etc., and had registered Formula One and Formel One. And there were 69 revocation actions that this German individual took as a retaliation. And the defense that Formula One wants to put forward was that it was an abusive process, that they had to be subjected to so many challenges. And what the EU IPO effectively held, that whilst you could put that defense forward, you don't have to show a motive in bringing a sort of a revocation action. And indeed, in this particular context, because there was a sort of a tit for tat between the two entities challenging each other's marks, there was nothing wrong with these particular challenge, albeit that there was a lot of them. We've also seen Google, who has a huge reputation, successfully challenge someone who tried to register Google Car in respect to autonomous vehicles. That's obviously not Google's main business, but there were press releases that it wanted to enter the space. And they were able to rely on their significant reputation worldwide in respect of a variety of other different things, such as search engine services, to challenge this registration with what would be dissimilar goods and services to what their registrations were. We've also seen what are some clarification around what might be considered sufficient use within the EU. Here, given the context and sector concerned, it was held that intensive use by 2 cafes in Barcelona was enough to show substantial use within the EU, albeit it was one city, not multiple cities, and in one jurisdiction. Given the particular services concerned, that was permissible, albeit it was very localized in the city of Barcelona. And then we've seen a very recent decision in the UK, actually, where there was a passing off case taken unsuccessfully. And it just does reiterate the point, and indeed what judges say in cases, that there is no tort of copying. It's not enough to show that somebody took an idea from my product getup or the like. You have to actually show, as was held here, that consumers are confused or deceived into thinking there's an association between the relative entities or the products and goods and services concerned. So this decision really reiterates the the need or the benefit in registering trademarks. And as I mentioned, let's say in the Absolute Vodka case, it is possible in certain contexts to register the shapes. Looking at designs, there's two decisions that I want to sort of look at. The first is sort of emphasizing the grace period and making sure that from an IP protection, what you're doing to protect and filing on time isn't sort of trampled on by, let's say, the marketing initiatives of the entity. So Puma have had their design registrations invalidated on the basis that they're not new and of individual character, because prior to them filing their application for the design registration, over 12 months before that, Rihanna had on Instagram publicized on social media those various designs, and indeed had worn the designs at a New York event. So the 12-month grace period to exploit a design didn't apply. It had predated that, and there were arguments about whether you can actually see the design fully in the photos, etc., but they weren't accepted. So it does very much point out the importance of ensuring that you file as quick as you can, albeit that there is this grace period, but you just have to be sort of careful on the dates. We've also seen a recent decision in the UK here between Marks and Spencer's and Aldi. The gin bottle on the left is the Marks and Spencer's version of a bell-shaped light-up gin bottle with gold flakes. Quite a novel concept, and one which Aldi imitated, to say the least, and indeed argued that they were ginnocent. So clearly there was a bit of a social media buzz around being challenged on this, and indeed some publicity garnered from it. In this case, it was held there was design infringement, which is quite interesting because many of the cases that have gone on before, there hasn't been design infringement. I've dealt with the Trunky suitcase in previous talks, but here there was design infringement. There was sufficient similarity between the two, and arguments such as the infusionist being written on the right-hand version by Aldi wasn't sufficient to distinguish the relevant design features. Looking at copyright, two aspects here. The first is we have seen for the first time fictional characters in books or in TV scripts, in this case, can be protected as a copyright work, and that is quite a significant development. The defendant in this case put in a show, a dinner show, which had the characters from Only Fools and Horses, and in particular Del Boy, and that character portrayed the Del Boy characteristics that we know from the TV show. So the copyright owners in the scripts took an exception to this. The script wasn't being used in the dinner shows, but indeed the character was being depicted. And they succeeded in that case in showing it was a copyright protected work, because when you look at the scripts, you could discern certain characteristics of Del Boy, such as the really poor French and some of the sort of phrases that he had used. So quite a significant development in protection fictional characters. We've also seen, and this is something that's come up with clients quite a bit, is the area of AI and how these AI models are taught. So Getty Images has taken a case in England against Stability AI because a lot of their images have been used in putting into the AI system to teach it so that it can obviously then in the future give outputs that are sort of beneficial. So the question here is there copyright infringement in using someone else's work in teaching AI models? And as I say, we have seen queries around that. And in the era of ChatGPT, it probably is something which we'll have to watch this space. Finally, in respect of patents, there's just one big development that I think needs to be noted over the last 3 months or so. We've had 3 decisions of patent interlocutory or preliminary injunction cases where the law has effectively shifted in favor of the patent holder. Historically, we've had cases, and in all patent infringement injunction cases, damages was always considered an adequate remedy because you could trace pharmaceutical sales and, they could be paid to the patent holder should the defendant not succeed in invalidating the patent, for example. Here, following a Supreme Court decision which tried to look at the test for injunctions, there's far more emphasis now on the presumption of validity of a patent, and it can be rebutted in circumstances where you can show in other European countries there's been successful challenges, albeit you haven't brought one fully through in Ireland. But in this particular Merck Sharp and Doane case, there was a decision of Sanofi where the injunction was granted because there wasn't sufficient demonstration of an invalidity challenge to allow that. We've also seen a Court of Appeal decision in the last couple of months in Biogen, where what was granted as an injunction last year was overturned. What was refused last year was overturned, and in fact, an injunction put in place, where, albeit there were other decisions in European countries for preliminary injunctions, which looked at, to a degree, on a preliminary basis, the validity of the patent, that was held not to be sufficient evidence. And in fact, what the Court of Appeal was suggesting is that a party that is resisting an injunction should put in expert evidence, independent expert evidence, to show why the patent is invalid. Pretty much an interesting development. And then finally, Bristol Myers Squibb, a very recent decision which is following suit. So we've seen a sort of a complete shift in emphasis in favor of rights holders here, where it's more likely than not now that injunctions for patents will be granted when sought. So moving on to Hazel, thank you.
Thanks, Jerry. So today I'm going to discuss three different areas. The first is going to be dealing with green trademarks in the EU. And then I'm going to move on to some updates regarding trademarks and classifications in the EU, and also some issues, trademark issues with going global. So first, in relation to green trademarks, something we've certainly seen as sustainability continues to come to the fore. There's been a massive increase in green trademarks being filed. A green trademark basically describes a class of trademarks that relate to products or services that are environmentally friendly. And we're seeing this across the board. It's not simply something that's relating to the energy sector. We're seeing, for instance, green trademarks in financial services for green mortgages, as well as in the space of fashion, FMCG products and building products. So we're seeing it right across the board, and our clients are filing for them more and more. One of the issues with green trademarks is the potential risk of greenwashing. And greenwashing basically are the behavior where the activities make people believe that a product or service is more environmentally friendly than it actually is. And so green trademarks can result in claims of greenwashing when they're used in a particular way and depending on the trademark. And we are seeing this in some cases at the moment. For instance, H&M has been taken to court in the US for class action in relation to its Conscious Choice brand of clothing in relation to greenwashing claims. So we are seeing this continue to increase. In the EU, we have existing legislation, and we also have some proposed directives that are going to have an impact in this space. So the directive, the UCPD, the Unfair Business to Consumer Commercial Practices in the Internal Market Directive, which has been around for quite some time, there's some guidance on that, which does state that if a trader uses environmental statements in their product name or brand name, then, and that's used for marketing purposes, then that's susceptible to the same substantiation requirements as any other environmental claims. So unless there's no environmental connotation in the actual green trademark itself, there's a good chance that you would be liable to be have to comply with that. We also have two proposed directives that will have a further impact on green trademarks. So last year, the EU Commission published the proposal for directive on empowering consumers for the green transition. And this defines green claims as being any message or representation which isn't mandatory under union or member state law. That includes any text, pictorial image, symbol, label, brand name, company names, in the context of a commercial communication, which implies that a product or service is environmentally friendly, has no impact on the environment, or is less damaging than other goods and services. So this is certainly in proposal stage at the moment, and will be proceeding in the next couple of years. Then we also have the Green Claims Directive, which was just published a few weeks ago by the EU Commission. And this is proposing a common criteria against greenwashing and misleading environmental claims throughout the EU. So the idea is to guarantee that consumers will have more clarity and a better understanding of environmental claims so they can choose their products accordingly. So environmental claims will need to be independently verified and proven with scientific evidence. So obviously there is an impact here on potential green trademarks, and it's something that people need to really bear in mind when they're going down this route to think about any sort of potential for greenwashing claims. So moving on to the next slide then, one of the other issues with green trademarks is the potential for descriptiveness. And we've seen a number of cases at EU IPO level over the last year or so where this has been discussed. So one of the cases here is the green trademark. This was for products, building products and services. And the fifth, sorry, just the last slide. The fifth Board of Appeal in the EU IPO held that the word green was laudatory in relation to these products, and also the use of the green leaf was actually merely descriptive of environmental products. So this trademark was held to be descriptive and not distinctive of the goods and services. So one of the other cases here is We Go Green. And similarly, the EU IPO was of the opinion that the English-speaking public in the EU would be of the opinion that they would understand what We Go Green means. And the image, the pictorial image that goes along with this wasn't enough to give it any additional distinctive character. One other trademark that has come up recently is sustainability through quality. And this was in relation to certain engineering services and products. And the EU IPO felt that this was descriptive and not sufficiently distinctive to warrant registration. And that case also reinforces the difficulty with slogan marks in the EU. And I've certainly found from working in other jurisdictions in here that slogan marks in the EU are that bit harder to get through than in other jurisdictions. And the Board of Appeal in this case said that the mark would be understood by the relevant public as merely being an advertising slogan and not an indication of origin of the goods and services. So it is something to definitely bear in mind with these types of trademarks. One good news story for the applicants is the Eco Earth Conscious Optics trademark. And that related to spectacles in class 9. And there was a third party that filed observations in relation to that mark and claiming that it was descriptive. And the EU IPO agreed and held that it was descriptive, and the applicant appealed. And in the course of the appeal, the fourth Board of Appeal looked at the trademark, and they looked at the word optic, and basically optic being a branch of science. And so as it's a branch of science that relates with visual and also electromagnetic light and energy, that a branch of science of itself cannot have any consciousness and certainly can't be earth conscious. So any consumer would need to take a number of mental steps to go from eco earth conscious optics to any sort of descriptiveness. So they dismissed the refusal, and the trademark has proceeded. So on the next slide is some tips for branding and rebranding for greener trademarks. Number one is, as always, undertake searches. Now in the green trademark space, this is becoming increasingly cluttered. So it is quite important to undertake your searches and make sure that your trademark is available for use and registration in the EU. Also take care with using trademarks such as words such as eco or green, because as you've seen from those cases, they can give rise to descriptiveness cases. Consider the EU IPO's harmonized green terms for your specifications. So the EU IPO has gathered about 85,000 terms that will be acceptable throughout the EU in relation to green products and services. So it's useful when drafting your specifications. Also with greener credentials, it may result in new applications if you've got some changing goods or new services, or also new jurisdictions as a result of the green credentials. So it is something to bear in mind if you're going down a green route, selecting green marks or changing your services, that you may need new trademarks. So moving on to the next slide then, I'm just going to go through some of the classification updates that we've had at EU IPO level. They published some updated guidelines at the end of, effective from the end of March. And it's given some good updates on classifications. Now, some of this has already been released by them last year, but they've given a bit more detail. Unsurprisingly, they've gone through downloadable goods and virtual goods and confirmed that they lack clarity, and you need to have further specifications. So there's some examples of acceptable claims there on the slide. So for instance, in class 9 for downloadable goods, namely downloadable multimedia files. So moving on to the next slide. NFTs, obviously they're still everywhere, and they have confirmed again that NFTs will not be acceptable of themselves as a specification in a trademark. So some examples of acceptable claims would be For instance, class 9, downloadable digital art authenticated by an NFT. Obviously, the thinking being that NFT really just certifies your ownership. So you can't have NFTs of themselves in the EU. So on the next slide, then, services relating to downloadable goods. So these are classed in line with the underlying nature of the service, taking into account its impact in the real world. So what this means is if you've got, for instance, transport services, they would traditionally fall into class 39 on the NIS classification. But if your transport services related to, transporting an avatar in a game, etc., then that actually falls into entertainment services. So that goes into class 41. So this is just, you have to be careful in relation to where that service should actually lie. So on to the next slide, we look at electricity and energy. And we've seen this come up in a number of applications over the last year in provisional refusals for local designations of IORs. And the EU IPO has confirmed now in the classification that retail or wholesale of energy electricity will not be accepted. And they've given some guidance there as to what will be acceptable in class 39 and 35. On the next slide, then, one of the new classification guidance relates to reservation services and booking services. That's not considered clear and precise, and they've given an example of what would be acceptable in class 41. So some further clarity there, I think, which is quite useful because anyone in the online booking space, tourism space, IT space could be using reservation services and booking services. So on the next slide is some UK IPO statutory guidance that they just published earlier this month in relation to NFTs, virtual goods, and metaverse related services. They've taken quite a similar approach to the EU IPO, but they've given some quite good examples in relation to acceptable claims. So it's worth having a look at the guidance note to see what will be acceptable in the UK. But you see they've given a bit more detail in class 9, and they've also clarified in relation to class 18, handbags authenticated by non-fungible tokens would be allowed in that class. So moving on to the next slide. They've also talked about some virtual goods, and they'll only be accepted if they are clearly defined. So a quite similar approach to the EU IPO. And also in relation to the metaverse, they'll accept services provided through the metaverse if they're in the same class as more traditional forms of delivery. But you really need to look at what the metaverse service is going to be. So for instance, if you're ordering food for an avatar to eat in a game, as opposed to ordering food for physical delivery, they'll go into different classes. So going on to the next slide, we're just going to look at going global. And so, in the last week, we've had some good news from Enterprise Ireland, and they said that their exports of Enterprise Ireland supported companies from Ireland were up 19%. With a record 32.1 billion euro in 2022. So this is the highest ever increase for Enterprise Ireland supported companies. So it's really showing that certainly Irish companies are going global, and we're seeing this more and more throughout the world. But often as companies increase their global footprint, they're really not thinking about their trademarks. And Dan will talk about this a bit more when it comes to China. He's got some great insight in relation to that. The obvious route for people to file trademarks in going global is the Madrid Protocol, because it covers 114 jurisdictions. There's a lot of cost savings and formality savings, and it's a single registration, so it is quite helpful. But there are some countries that aren't relevant, and it's not covered. Some important countries such as Hong Kong and Taiwan and South Africa, as well as some Middle Eastern countries and South American countries. So you need to go down the national route for those. One issue with the Madrid Protocol is that the international trademarks are reliant on the base applications. So if your base applications in the EU, all of your IORs will be reliant on that for the first 5 years. So if there's an issue with your EU trademark, it could result in your IOR failing as well. But while you can then convert it to a national, if there's an issue with your local trademark in the EU, it might be worth considering just filing for your national trademark in those countries instead, because they will stand on their own. So just on that note, I think it would be good now to pass on to Dan, who's going to give some great insight in relation to trademarks and IP issues in the EU, in China. Thank you.
Thank you very much, Hazel. If we can just go to the next slide quickly. Just a little bit about CIPS, trademark agency in Hong Kong with offices in Guangzhou, Beijing, and Shanghai. We've been around since around 2012. Good mix of clients, top tier, blah, 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 blah. You don't need to see all that. We can go to the next slide. So just really quickly on my background and as it's relevant to this presentation, I was actually in-house with both Louis Vuitton and Nokia, and this presentation kind of comes out of my time with those two companies, particularly focused on the IP security aspects of distribution and supply chain relationships. We can go to the next slide, please. So this is a very, very practical presentation. It's going to talk first and foremost about the basics of China IP law, so you've got an understanding of the lay of the land. And then we'll move more into practical, very commercial aspects of doing business in China, not necessarily selling to consumers, but manufacturing your goods there, using it as a base of export, and trying to distribute your products there. First and foremost, start with trademarks. The main thing to remember is China is what's called a first to file jurisdiction. Whoever gets to the trademark office with an application first is considered the putative owner of the trademark. Even if you've been using it overseas, even if it's identical to a mark somebody else has filed for in other countries. You can file the full range of marks in China: word marks, sound marks, color marks, logos, Chinese language marks, very, very important to the extent that you're actually distributing product in China and you want to reach out to Chinese consumers. Another interesting aspect of Chinese trademark law that needs to be kept in mind is we have a subclass system. So every given class is broken down into similarity subgroups. Class 25, for example, for clothing, you would need to file to specify if you want to cover shoes and hats, two separate subgroups. Those goods are considered per se dissimilar, and you can have identical marks from two different companies coexisting in the same class as long as they don't specify goods in overlapping subclasses. And that subclass system is very, very important, particularly in respect to the problems we have with piracy in China. As far as copyrights go, China is a signatory to the Berne Convention, so pretty much any rights you would expect in other jurisdictions, you'll have in China as well. China does have a registration system where you can apply for and obtain a Chinese language copyright registration certificate. No substantive review of those. They're granted pretty much as a matter of course. An interesting aspect and something to keep in mind on the enforcement side is the possible availability of protection for copyright in works of applied art. This is probably most akin to unregistered designs in the EU. Primarily applies to things like furniture design, something with a much less functional, much more artistic aspect to it. Toys is another classic example. For design patents, no substantive review of those as well. The only way you can you'll get a registration certificate just by applying for the design patent, but to enforce it, you really do need to have it reviewed by the China Intellectual Property Office to confirm that it is indeed novel, patentable, et cetera, et cetera. So those evaluation reports become quite important. Same goes for utility models granted without substantive review, and you do need that additional evaluation in order to enforce it. Now, something to keep in mind in respect of our invention filing system here in China, it's quite often a smart strategy to consider dual filings for a given invention, filing an invention patent and a utility model patent application at the same time. The utility model patent will be granted right away, and once you have it evaluated, you can enforce it. And eventually, when the invention patent becomes granted 2, 3, 4 years down the line, you can actually start enforcing that. You just have to withdraw the utility model so you avoid any double patenting issues. A lot of companies with products that are very hot that they want to, like a toy company, for example, that has a great new game. If they file an invention patent for that game, they're really missing out if they don't file a utility model, because the invention patent could take 3 or 4 years and the game might no longer be popular by the time they actually get rights. Filing that utility model application at the same time allows them to basically immediately enforce. All of the rights discussed, trademarks, copyrights, and design patents can be recorded with Chinese customs. Because of the problem of counterfeiting in China, the Chinese government does inspections of goods both going out of China, but coming into China, but also importantly, going out of China. So exports are checked by PRC customs, and you can record given rights with customs and ask them basically to search shipments to see whether any infringing products are contained in those shipments. China also has its own domain name system. If, again, you're going to be looking at marketing to Chinese consumers, you might want to consider .com, .cn, or even Chinese character domain names in order to make sure that you're getting the best reach to Chinese consumers. Next slide, please. So China is not only the world's factory, it's also the world's undisputed champion for counterfeiting and for piracy at the trademark registry. Pirate IP registrations don't only occur at the trademarks, they also pirate designs and utility models. Because of the non-substantive review of designs, for example, I could actually today go and file an application, a design application for the design of the Coke bottle, and I would get that design registration. It wouldn't be rejected out of hand because it's copied somebody else's famous design. So it's very, very common for pirates to file trademarks, steal trademarks from the actual owner, file design applications for existing designs, existing utility models, both as a means of trying to corner the market and extort the actual owner of those rights, but also as a bit of a shield to protect themselves if they're engaging in counterfeiting. Having those registered rights could be used as a means of excusing their infringement. China is also a hotbed for the manufacture and sale of fakes. Factories all over the place in China are churning out not only genuine products and not only products from of companies that we know worldwide, they're also producing fakes to sell both in first world countries as well as, and to a very large degree, third world countries. Now, these products can be found in the online sphere. This didn't always exist when I was working at LV. We were much more looking at brick and mortar markets, and those are still out there. But nowadays, the easiest thing for someone who's looking to buy fakes is to hop online, and you've got a plethora of websites that are pushing these products. The holy grail, of course, and we're talking about doing enforcement, is looking for those factories that are manufacturing the products. And that's something that we'll talk about as we go on further. Enforcement, China actually has a fairly robust IP enforcement system, full range of possibilities, administrative enforcement, including raids from market supervision bureaus, primarily focused on trademark infringement. It's a little bit more difficult to get that type of enforcement in respect of copyright or patent infringement. Civil is always a possibility, filing a lawsuit, sending a C&D letter, and Chinese courts, and particularly the IP-focused Chinese courts, we have IP courts in larger cities like Beijing, Guangzhou, Shenzhen, are very, very skilled with intellectual property cases, very experienced in dealing with those, and that can be quite helpful. If the amount of counterfeit product, and we're talking trademarks here, rises to a certain monetary value, you might even be able to enforce criminally. Counterfeiters in China do regularly go to jail. I've got a case right now that wrapped up where we got a 4-year sentence for a pirate who was ripping off my client. So criminal punishment will bite hard and can be used as a means of attacking fakes here in China. Next slide, please. Now, you may already be in China. You may be considering to go into China. It's always a good idea to get a bit of a status check and see where things are by running a simple series of pre-engagement checks. First and foremost, trademark registry is a great place to start. By looking at the trademark registry and identifying marks that have been filed that are similar to your mark or more worryingly identical to your mark, you can identify possible oppositions that you might want to file. Where a mark has been gazetted, is a 3-month opposition period, and you might want to try to stop that mark from being deemed registered. You could consider non-use cancellations if the mark has already been registered and doesn't appear to have been used by a pirate. And it's very common for Chinese pirates to file for marks and basically warehouse them, not use them at all in respect of any products, more likely just waiting along like a lottery ticket that the actual brand owner is going to come and buy the mark off of them. So non-use cancellations are a very viable option of eliminating registered marks. And finally, invalidations. And generally speaking, for invalidations, we're talking about knocking these marks out on the basis of bad faith, on the basis of the true owner of the mark having been slow to the trademark office, and the pirate having taken advantage of their knowledge of this gap in the true owner's portfolio to file their own application and to misuse and abuse the trademark. Now, bad faith in China doesn't mean what you and I would normally think it would mean. You know, if I've exactly copied somebody's mark and for use on the exact same goods, bad faith would seem to be pretty obvious. But in China, given how common and day-to-day pirates filing for 10s, 20s, dozens of marks is, that really doesn't rise to the level of bad faith. You need something extra. You need the pirate filing for the marks of 20 or 30 different brand owners. You need the pirate actually manufacturing counterfeit product. You need the pirate having familiarity, awareness, maybe because it's an ex-distributor, or maybe because they're in the same industry, something that really ties them and shows a higher level of culpability than just they stole this one mark. Now, once you've identified marks on the register that appear to have been copied from your mark, these are individuals that you want to look at. Why did they file for your mark? Are they using the mark that they've applied for as cover to cover counterfeiting that they're actually engaging in respect of your brand? So it's very, very important to consider those targets. The bad faith evidence I discussed, sometimes the only way you can get that evidence is actually on-site investigations, talking to the pirate and asking them, why did you apply for the mark? What do you intend to do with it? Are you interested in selling it? Of course, in a covert way, but funnily enough, pirates in China are actually very happy to brag about the skullduggery they're engaged in. So those on-site investigations can be quite successful. If you find any logos of yours that have been ripped off, you can rely on copyright in that logo, depending on the nature of the work, as a means of overcoming that registration. You do have to, of course, prove your ownership of the copyright. So you want to make sure that your assignment agreements are airtight. If it wasn't created in-house, if a design company did it, for example, because you will need to establish to the SNIPA, the Trademark Office's satisfaction that you actually own the copyright work. Customs recordals is also something you want to consider, certainly for your own marks, to make sure that you've got your rights recorded with customs. And if there are any counterfeits of your product leaving China, there's a good chance customs will catch those. But you also want to take a look, particularly for any of these pirates who might have stolen your trademark. And if they're threatening, or it seems like they may threaten your business in China, either your supply of goods from China or your distribution of products there, you want to check to see whether that pirate has recorded your stolen mark with Chinese customs, because that would give them an opportunity to seize your genuine shipments of products leaving China through that recordal of that mark. We'll talk a little bit about how you might be able to avoid that later. Finally, it's always a good idea to do a bit of a benchmarking online survey just to take a look at the nature of the counterfeit products for your brand that are being sold, the prices they're being sold at, whether there are any apparent manufacturers or larger scale distributors that might be good targets for possible enforcement action. Physical markets can be inspected as well. Depending on the product, they do tend to clump particular types of manufacturing, particular types of products in particular cities and provinces. So that is something to consider depending on the nature of your product. Next slide, please. Now, if your mark has been stolen by a pirate, first and foremost, what you really want to do is look at how you might be able to knock that pirate's mark out. Now, if the mark has only just been applied for, it hasn't yet been gazetted for approval, you might consider filing an interference letter. This is completely informal. There's no absolute guarantee that it's going to work, but depending on the facts in the case, we are having good success getting examiners to basically reject marks before they ever get through the gazettal. Hopefully it's because, we like to think it's because of the interference letters, but once again, cannot hurt. If the mark has become approved because you didn't see it in time to file an interference letter, or the interference letter didn't work, I've already indicated you have a 3-month opposition period after gazettal. You have up to 5 years after the date of registration to file an invalidation action, which gives you a good period of time to identify that type of bad faith evidence that I was discussing. If an invalidation is going to be a bit of a too difficult case to run, maybe because of slight dissimilarities between the marks, or it's just a small scale pirate that isn't likely to be found to have engaged in bad faith behavior, you might consider non-use. That's 3 years after the date of registration as published. That's always a possibility. And of course, if you lose the opposition, the invalidation, the non-use cancellation, you can consider administrative appeals of those decisions, as well as a few rounds of court appeals. Keep in mind that if your mark has been pirated, certainly you want to get your own application on file and start working on getting rid of the pirate mark, but there is going to be a significant delay, probably at least 2 to 3 years. And if the pirate uses all of their possible appeals, maybe longer than that. You certainly want to consider, if it's a logo involved, getting that copyright, using your design, whatever other protection you might have, as a means both of ensuring that you can do business in spite of the fact that the pirate has stolen your mark, but also to use those registrations as a means of attacking the pirate mark. If the mark is well known, particularly well known in China, but certainly well known overseas as well, that's another ground of attack you can consider if you haven't registered a well-known mark. Just keep in mind that the bar for having well-known status recognized in China is exceedingly high. When I was at Louis Vuitton, we were able to get well-known status for the LV logo, but I kid you not, the stack of evidence was probably about 2.5, 3 feet high, just to get that through. Many meetings with the judge, blah, 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 difficult time. You can also, particularly where the pirate has actually threatened your goods, your factory, or your distributor, you can consider seeking a judicial declaration of non-infringement. This can be very, very helpful in overcoming the pirate's registration, where you basically have a judge saying, yes, in light of the facts, particularly the bad faith, the pirate, dissimilarities between the marks in question, your use of the mark in China is not an infringement. Now, another thing you consider, and I spoke a little bit about this before, is what's called the OEM exception. If you're manufacturing in China, and although a pirate has stolen your mark, has registered your mark out from under you, and has perhaps even recorded that mark with customs, you may still be able to get your goods out of China to the extent the country that you're sending those products to, you have your mark registered in that jurisdiction. So this OEM exception doesn't exist in law. It's not written down. It's purely judge-made law, but it can, on occasion, allow you to get your goods out of China because, technically speaking, for the purposes of the OEM exception, manufacture in China where the goods aren't sold to Chinese consumers isn't considered quote unquote trademark use in China. This isn't an immediate win for you. The OEM exception generally has to be litigated through the courts, but it is a means of overcoming that pirate registration, blocking you from using China as a factory. Next slide, please. So when you're going to start your business in China, you want to do your due diligence. China is a bit of a wild west, so it's particularly important that you be wary and you be careful as you proceed. Now, certainly referrals are a good way to start identifying partners, possible manufacturers, possible distributors. Before COVID, of course, it was very easy to come to trade fair. The Canton Fair in China in April and October is a classic opportunity for you to come and look at potential partners that you might want to work with. Referrals from other people in the industry, other people who've had experience with it, with a particular manufacturer is a good thing. Distributor is a good thing. You might consider going to B2B and B2C sites, Made in China, AliExpress. These are opportunities kind of for a first look at who these people are. Trade fairs will start becoming a more common thing now that China has finally put the brakes on their COVID zero policy, so that's something you might want to consider, but that really is just an initial meet and greet with someone who's going to show you all their best, best sides. Factory visits, store visits for distributors, absolutely vital. You really do want to be on the ground, look the people in the eye, take a look at the facilities they're going to be working with, the quality of the work they do before you consider signing on the dotted line with them. Keep in mind, though, that in any meetings you have, you're going to walk away fairly blown away with how professional these Chinese partners are, how eager they are to please. If you have an opportunity to travel China, you're going to have the red carpet laid out for you, but this is just business. Be objective, do your homework, look into these companies before you sign on the dotted line with them. Next slide, please. So what kind of homework do you want to do when you've identified a partner that you might consider working with? First and foremost, take a look at to see whether they've applied for the IP rights of any other party. Have they filed for pirated trademarks? Have they filed bogus design applications, ripping off other designs? Have they been sued by ex-partners for non-payment of royalties? You can talk to other trade partners, as I said, if they're a distributor and they're distributing a number of foreign brands, ask for a referral to one of those other brand owners and have an interview. See how satisfied they are with the performance of the distributor. You absolutely want to make sure that they're willing to sign a strong IP agreement that absolutely protects your rights in China. A refusal to sign an IP agreement to me is basically an indication that this is not a partner you want to work with. If you're talking about distributors, you really want to get a sense of the scale and experience and the scope that they have. It's not uncommon at all for putative distributors in China to put forward, boastful claims about hundreds of outlets across China. And once you scratch even a little bit below the surface of those claims, it's not uncommon to find out that they really don't have that many outlets at all. Maybe it's 3 or 4 outlets puffed up to be 100. So doing your homework is very, very important. Next slide, please. Now, I'm a firm believer in having detailed agreements in China. A lot of people will say, well, they're going to violate the agreement anyways. What's the point? Better to have something in writing and something essentially on its face enforceable than to have nothing. First and foremost, always make it bilingual. You don't want to give a Chinese partner who's ripped you off an opportunity to say, I didn't understand English. I just signed what was put in front of me. My business was in trouble and I just needed to get the money in the door. I've seen that excuse come out a number of times. So bilingual really is the way to go. You want to provide in the agreement for detailed, unannounced audits, inspections, on-site visits. Give your team the ability to walk in unannounced and see what's actually going on when you're not there with the red carpet rolled out. Ideally, you'd like it to have it legalized and notarized. That means notarized is signed in front of a notary in your home country, go up through the home office, and finally through the Chinese consulate. That will make that document immediately enforceable in Chinese courts. If you don't do it at the time you execute the agreement, you're going to have to do it at the time you try to sue on the agreement. So might as well get it done early. You want to have strong IP and dispute resolution provisions. Choice of law, because it's an agreement between a Chinese party and a foreign party, PRC law permits you to choose foreign law. So if you're more comfortable having Irish law, that's fine. You can do that. Just keep in mind, it might be difficult for a Chinese court to enforce or interpret Irish law. So law of China, or maybe even better yet, law of Hong Kong, for example, which is right next door, separate system, common law system, one that you're much more used to if you're there in Ireland, is a very, very good option. Arbitration versus litigation. I'm a strong believer in arbitration for particular disputes. There are types of disputes that become kind of bet the company disputes, and this is this emergency clause section I'm discussing next, where let's say your manufacturer is actually producing goods, your branded goods, and selling them out the back door. You don't want to have to arbitrate about whether that constitutes a breach of the agreement. Those, by the terms of both your contract and PRC law, are unauthorized goods and are counterfeit. That's the type of situation you want to provide for by making sure you have the ability to go to the police, to go to the MSB, to get an injunction from the court. You don't want to be stuck in arbitration in Ireland when that type of issue comes up. So you really want to have, you know, a good, solid, practical agreement that's very workable and very enforceable. It's also important to provide for liquidated damages. This is a pre-damages estimate of what kind of harm would be done and how much harm that would, and what that harm would cost to the brand owner. Those are enforceable as long as they're not crafted like a penalty. And actually, and quite creatively, you can use those liquidated damages clauses if you assume your partner is going to rip you off, is going to, you know, cut corners, is going to potentially sell products out the back door. You can't shut your supply chain down overnight. So using those liquidated damages provisions is basically a punishment and kind of a requirement that the infringer pay up to put the scales back in balance before you'll continue working with them, can be quite a nice thing. And I've seen brand owners basically fund their enforcement programs by creative and selective use of their liquidated damages provisions when they've caught their partners doing the dirty. Next slide, please. So, no, next, that's the right way. So in this respect of manufacturing relationships, don't go with just a purchase order. I have lots of companies that have been doing business for a long time on PO. So they're like, well, Dan, it's worked for 10 years for me. Why do I need to worry now? It's never a problem until it's a problem. And relying on some fine print in a boilerplate purchase order versus a formal supply agreement written in Chinese, it just, there's just no comparison between the two. I already spoke about the OEM exception. You will want to have reference to the OEM exception, particularly if your mark has been pirated, in that supply agreement, which basically ensures that the manufacturer acknowledges the issue, recognizes and confirms the ownership of your rights overseas, is prohibited on making any in-country sales, because in-country sales, as opposed to exports, would not be considered safe under the OEM exception. Those would just be sales. So you need to clarify that in the context of the agreement. Ownership of molds and tooling. If you have the supplier creating the molds and tooling for you, you want to make sure that it's very, very clear that those belong to you, that those are to be returned upon completion of the relationship, the end of the relationship. You want to make sure that your brand is marked on the molds and tooling. Ideally, you'd have a middleman hold on to the molds and tooling for you if you could, or have a system in place to get them back if and when the balloon goes up and you need to. As far as distribution agreements go, you will want to make reference to the possibility of recording the trademarks with the PRC TMO. It's not required under Chinese law that you record them. I mean, technically it is, but it's never enforced, so very few people do it. Be wary of your distribution partner asking for an authorization letter and the type of language that is put into that authorization letter. Those are misused and abused, and with the ability to scan things and shoot them off, you will see those authorization letters showing up on the websites of online sellers of your products, of even counterfeits of your product. So I'm very wary of those, and I really police those and control those very carefully. You want to have strong language specifying supervision and quality control, that you're the final arbiter of brand image and how your brand is used in advertising. And you want to make sure that you actually follow through on that. It's not uncommon for Chinese distribution partners to go off the reservation and really, make use of your brands in ways that you didn't expect and quite frankly wouldn't tolerate. You also want to make sure, given that the distributor is going to be rising and falling, their profits are going to rise and fall on the basis of how clean the market is, and the presence of counterfeits in the market, which may actually gut their ability to sell products, to sell your genuine products. You do want to account for the possibility of relying on that distribution partner as a free investigator. They're very motivated to go out and find fakes in the market and to try to take action against fakes in those in that market. But keep in mind, someone's going to have to pay for the enforcement actions against those fakes. So considering in advance of that distribution relationship, what the status of fakes is in the market, how widespread it is, the sophistication of your distribution partner, the strength of your IP, all those things can and should be described and discussed and thought about ahead of time in your distribution agreement. Next slide, please. So monitoring is a very, very important thing in China. Trust but verify, proactive, not reactive. Don't sit back and wait for counterfeit products that are basically so high in quality that they must be manufactured by your own factory, by your own partner factory in China. Don't wait for them to show up in Ireland. Be there with an investigator doing an undercover check at the factory on a quarterly basis. Maybe consider those unannounced audits that I discussed. Don't wait until the end. Proactive, not reactive. Conducting regular online surveys, conducting physical market surveys around the factories that you're manufacturing in, because quite often sample products overruns will show up in markets, I kid you not, right next door to your factory. If you've got suspicions, if you've got concerns, consider planting an informant inside the factory. Keep an eye on offshore markets and see when products are showing up that look a little bit too close to your genuine product. Monitor the trademark gazette regularly for new pirate marks that might come up. Consider, particularly even before you start a relationship with a factory, for example, when I was at LV, we always sent investigators in undercover to basically suss these factories out and see what their policy was in respect of manufacturing products bearing brands that they didn't have a right to. And if a factory tells you right off the bat, oh, it doesn't matter that you don't have a right, just give me a letter saying that you do, and that'll be good enough for me. That is an absolute red flag. Walk away from that factory. So really proactive, reactive, doing your checks. Use your provisions in your strongly crafted agreements. Use liquidated damages provisions if you need to. Seek injunctions where you need to. Don't be afraid to actually rely on your rights. Monitor before, during, and after the relationship. And after is quite important because remember, when you had a distribution partner you worked with for 5 years or a manufacturer you worked with for 10 years, they know your product, they know the materials, they know your other suppliers, they know how you export product. You basically, when that relationship ends by agreement, you have just created an incredible possible competitor. So it's really important 3 months, 6 months, a year after that relationship ends, or after key members of the partner's team, for their production manager, for example, leaves the factory. What have they been up to? Have they set themselves up in business going after your customers? If they set themselves up in business manufacturing your products, using your supply chain, all very, very important. Next slide, please. I think we might be close to done. We are. Wow, that was just on time. If anyone has any questions, I'm sure that Hazel, Jerry, and myself will be happy to answer them.
Thank you, Dan. We do have a few questions in the Q&A for the webinar. We are very tight on time now at this stage, but just briefly, Dan, there is a question about what your views are on the rule of law in China compared to maybe expectations in more Western democracies, if I put it that way.
Look, China has been moving ever since it entered the World Trade Organization in 2001. It's been moving more and more to a system that Westerners really would recognize, a very court-based system. So if you get yourself in front of a Chinese court, my view is more and more you will see justice done. There are less and less outrageous decisions where you really feel like I've got to go to the embassy, I've got to go to the consulate. So from a rule of law perspective in the courts, I think the picture is quite good. That being said, from the perspective of the trademark office in particular, which is the one we deal with most often, given how manufacturing and distribution being so tightly tied to trademarks, the trademark office and the TRAD, the review body, are dealing with such an absolute backlog of cases that they're starting to see, they have been for the last few years, seriously cutting corners, issuing decisions that are just outrageous. Absolute grounds of refusal are being used all the time now in cases where it just makes no sense at all because it gets the case off the docket. So courts, very reliable. Trademark office, expect rough waters.
Thanks. There's a question here about, as ChatGPT is becoming more popular, do you think current IP laws are sufficient to deal with it? I mean, just to take that very quickly, I think we've seen problems already in ownership, I suppose. How do IP laws as they currently stand deal with ownership in the context of AI? Can an AI actually own copyright material that's produced? And indeed, once something's produced that perhaps infringes, who do you sue in those circumstances? So I do think they probably do need to look at, in certain contexts, around ownership and enforcement, whether the law needs to take up with AI. I mean, I don't know, Dan, whether you have a view on that as well.
Look, I would say that the Chinese system is not in any way, shape, or form prepared to deal with ChatGPT. The biggest problem is I can imagine a bunch of Chinese pirates who are thinking up incredible creative ways to misuse and abuse it. So it will be some time, I think, before we know just how bad it can be from an IP perspective. And I think it'll be even longer before the PRC system is able to catch up and to adequately deal with what is usually a very fast-moving group of pirates who misuse and abuse these things.
Okay, maybe we'll take two more questions very quickly. Hazel, there's one here. What are the proposed penalties under the Green Directive?
So as it's a directive, basically it just will be giving guidance to the relevant member states, but it'll really depend on what they need to make sure that they fit the crime effectively. But one of the things that is coming in basically across the EU and already is in, but does apply to the Green Directive, will be the maximum fine being a minimum of 4% of the annual turnover in the member states. So, and that's pretty much across the board now in the EU.
Great. And just maybe we'll just end with this one. There's a question around the Aldi and little social media cheeky quips about being innocent. Would that ever be used in evidence against them and showing intent to infringe or take advantage of a brand's reputation? I mean, just taking that briefly, I mean, we know from the McCambridge decision, our Supreme Court, that intention to pass off is irrelevant. And in fact, in the vodka bottle case that I'd mentioned, even though they had clearly copied, that wasn't a factor. I could see that being relevant in the context of injunction applications where you will put evidence forward that they knew what they were doing or perhaps lived dangerously. But to show intention is not relevant. So, as I said, it'll only just, I think, in the context of litigation, color or paint, how it might be looked at upon by a court. I mean, I don't know, Dan, just to conclude very briefly, whether intention or what sort of evidence you have to go into on the infringer's activities you need to show some infringement.
Look, any evidence you can show of practically speaking why this pirate filed for the mark or why they filed for this design patent is absolutely key. Bad faith is very difficult to prove. The bar is very high. So words out of the pirate's mouth, boasting about why they filed for this mark, a recording made by an investigator, comments on a website, reviews or whatever it might be, this Ginnocent thing, that would be very helpful in the context of an invalidation case in China, where you really were trying to prove motive. And it actually does become quite important, given that these pirated marks were always trying to explain why the pirate filed for this mark and not another mark, and why it's troublesome.
Okay, thanks very much. I think we've gone over the time, so we'll sort of leave it there. There will be a feedback survey which will pop up after this, and indeed, please give us future topics that you'd like to have discussed. On the 10th of May, we do have our commercial contracts webinar, which you saw advertised at the start as well. So I'd like to thank Dan for giving insights into China and Hazel for her discussion as well. And thank you all for very much attending on World IP Day 2023. Thank you.
Thanks, Jerry. Thanks, everybody.
Thank you.